amounts to electoral justice. First of all, that the Constitution should be on the ballot. That if it means bringing all the ballot papers from all the 770-something thousand polling units for counting before the panel, even before the Supreme Court, there's nothing wrong with it. It accords with electoral adjudication. That is what it is meant to be. When you attach so much legalese, so much technicalities into electoral education, you kill the concept of election. You kill the concept of the mandate, which comes from the people, which is a fundamental right. Article 13 of the African Charter clearly spells it out that it is the right of a person to participate in the electoral process either freely or either directly or indirectly. You also find out in Article 19 of the Universal Declaration of Human Rights. You also find out in Article 19 also of the Covenant of Civil and Political Rights. So we have to get it very correctly that the proper adjudication for election petitions must be focused specifically on the ballot and nothing more.
Many, of course, will argue that if you are focusing solely on the ballot, there are processes that appertain to the ballot itself. And if those processes aren't right in the perception of a litigant, then you also have to resolve those processes. I'll come back to you in the course of the conversation, but let's return to our studios here. So one of the issues that Oguche raised, again, it's also been in the public domain. I recall this was a matter that was equally raised at plenary, excuse me, in the National Assembly sometime in the past. It had to do with technicalities rather than justice, as some persons will say again in layman's language, to say there's too much focus on technicalities. Yes, election petitions are sui generis, they are unique, there are ways to go about them. But if the end is justice, people are asking the question now, I mean, for those who know, look, if the origin of the principles of equity was to deal with the hardship occasioned by the strict application of the law. In other words, if you were to present your case in a particular form and you didn't present it in that particular form, then you lost the case whether the merit of it was examined or not. Which is why Buche was earlier talking about originating summons and writ of summons. I know that there are different, as much as we can explain it to our audience, how do we get around this in our electoral jurisprudence in particular, so that at the end of the day, there is electoral justice?
First of all, we should understand the concept of justice in our modern day society. It's justice in accordance with law. And you said it. In trying to achieve this justice, there are processes which you must follow. You brought in equity. We should not turn this into a law seminar. So we have to be very careful that we're speaking to a much broader audience. So I'm trying to break it down as much as I can. But election rights, in a sense, are according to the law and the processes outlined in the law. You can't stray too far outside of the scope of the law. So a lot of these things now, you say, look, do it in accordance with what the law says. That's why I said, for example, we should place too much reliance on social media and the evidence, quote unquote, that we see, in fact, that we see from social media, because they are not tested. So if you say justice, I can, from this recent presidential election, I could have just said, okay, I've seen so much on social media. Based on that, I can say the justice means that X won or Y won, or the declaration was good or the declaration was bad. But we have to be very careful. And I agree with him that, yes, there are certain fundamentals that have to be complied with. And the base thing, and I think even the Supreme Court has said so, basically, what is the expression of the will of the people? That should weigh heavily. They've said so. How often they have followed through with that is a totally different thing. People still don't understand, for example, Amechi against INEC. Amechi's case, why Amechi, who did not partake in the elections, in the eyes of the common man, was returned as governor against Omehia, who did not partake in the primaries. A lot of the time you are balancing different issues and different concepts. Now, Amechi was named, for example, I'm taking a past example that is very popular, and I'm trying to avoid the present one, because those are probably subjects of juries are going to be subject to litigation. Now, in that case, for example, we said you cannot substitute somebody who won the primaries except with good reason, verifiable. But the PDP went and they substituted, did not give any reason about Omega. Now the Supreme Court made its decision, and in his own eyes, in the eyes of the law, not in the eyes of anything, in the eyes of the law, based on their own interpretation of the extant acts and regulations, Rotimi Amechi was the candidate of the PDP. And since the PDP won the election, there's no need sending that case back to the electorate. The electorate has voted and they voted for PDP. So, being the candidate of the PDP, because in independent candidates are not allowed, being the candidate of the PDP, Rotimi Amechi was the candidate. That's why I said, go and swear him as governor. To some people, did that make justice? Some people say yes, others will say no. But so depending on what prism you are looking at the issue from, most of the more popular cases, there is sometimes a misunderstanding of all the facts or issues presented before the court. As Yusuf Usman said a while back, a lot of the time, how do you commence a process? The Federal High Court rule says you do it by a protocol or written summons. You don't need to call witnesses. All you have to do is swear to an affidavit supporting your claim, and then the other people that are disputing it swear to another affidavit. But the Supreme Court said no. If the facts are so disputed, for example, if you allege forgery, fraud is a serious criminal offense. You cannot do it by affidavit evidence. You must call people so they can be cross-examined. You must tender documents. You must call experts to look at these documents. But these things also take time. The essence of why the chief judge of the Federal High Court made it that you should come by way of originating someone just by to make it quick. Because it's 180 days. You must file a case, hear a case, and one of the things we must commend the judges for is that they have tried not to allow any case lapse. They have tried within what is human to ensure that a decision is given on every case. Because if you file a case and people did that and it's 181 days, the case lapses. You cannot even appeal, you cannot do anything. It's just that will not meet the ends of justice. So these are the things. And by the way, equity doesn't come because the rights are statutory rights. They are rights given by the Electoral Act or by the Constitution. You cannot now bring any other thing. It's not the common law rights. You cannot bring other issues. So you stick to the laws and the framework and the guide that has been provided in the law.
Mr. Oguche, tell us something, because yes, you say it is the right, and I agree with you, of any aggrieved person to seek redress rather than resort to self-help. But it appears also to have just become part of our electoral process, beginning with the primaries that sometimes are just nothing but acts of shenanigans, and somebody will let you go to court. In other words, persons appear more interested in being respondents rather than petitioners in election matters or the prelude to election matters, rather than doing the right thing in the first instance and then reducing the volume of matters that courts have to deal with. How do we get around all of this and attenuate the frequent penchant and say go to court?
Before I go into your answering your question, I must express my satisfaction with the views expressed by Sate Yamo. I think he has coming from the background of INEC. I think he has quite a volume of experience, and based on his interaction with some of these principles directly. But I am saying that if we now sit down to discuss the concept of justice, we can be here till the next 5 years. I will not conclude it. The varying views of the jurisprudence on legal theory, from Hans Kelsen to Honorable Justice Holmes, the realist school, the legal positivism. But if you boil it down to elections, you now know that you are talking about nothing but the popular will, the expression of the popular will. That is the ballot. And that pertains to sovereignty. So if you're saying that justice in election petitions is justice as to law, sovereignty is also as to law. Themes and directive principles of state policy state very, very clearly that sovereignty belongs to the people from whom government exercises its power and authority. So it is not simply that maybe we are going to rely on facts if you are dealing with the ballot, or you are going to rely on extraneous matters that are outside the law if you are dealing with the ballot, because the ballot itself is law. Kinsey was here one of those programs where you formulated a principle that I find unassailable, that the ballot also has a human personality. Unfortunately, our electoral law does not allow me, for instance, to go and challenge an election petition in the courts. so to speak. But then we still have to boil it down to the fact that persons that are aggrieved by the election process have the right to express themselves by ventilating their grievances in the courts. And when they do that and the courts fail to satisfy their yearnings, of course, you know how the effect it will have on the law, on jurisprudence, on societal development, on peace, on tranquility. And that is why we find ourselves in this sorry pass, that all years of adjudication have not been very much satisfactory. Because somebody had not explained to me satisfactorily why somebody who came the fourth place in an election is the winner of that election, or why technicalities should be applied in terms of the quorum of judges or justices, and the apex court to rather throw away the petition instead of taking it back to that particular panel to form a quorum and take a decision on it, as happened in the former Osun state elections, not this recent one, the past one. A whole lot of issues are there. And the public confidence in the judicial system is lowering every day to very drastic levels. We have to take these things carefully. And that also answers your question to a large extent, because a lot of theories have been propounded as to what happens. Is this the weakening of the judicial system? Is it the undue interference of the system by political elites? Is it the fact that the Constitution has made it possible that the executives are the ones virtually running the judicial system in terms of finance, in terms of appointments, in terms of even discipline? And the NDC have been found to be susceptible or vulnerable to arm twisting tactics sometimes. These things, we have to bring them to the open forum, because we are trying to create an ambience for the good of this country and for the development of our jurisprudence, particularly in the election matters.
Yes.
The recent elections of last week has been bumped with a lot of objections all over the place. Should that be the case? If elections are free, fair, credible, and transparent, I bet you, Kingsley, that there will be less of election litigation in the courts than what we have now. Thank you.
Same question that I posed to Festus Oguche earlier, I would also like to ask you. The penchant of persons who, as you earlier indicated, do not abide by their own party's rules, do not abide by their own party constitution in conducting primaries, and therefore give rise to litigation. People say, go to court, that's for pre-election matters. And then when it comes to election proper, where all kinds of shenanigans get to take place in some instances, and you say, look, you go to court. And some persons have argued that it's usually mountain to climb for a petitioner, particularly if you're having to prove electoral fraud. We know how difficult it is, we know how painstaking and how costly it is. All you have to do in the pressure cooker environment. I mean, Adam Soshomole will tell you how difficult it was for him in 2007, 2008 to get the governorship of Edo after April 2007 elections. I recall that case vividly because one of the publications of the Nigerian Observer was taken as Exhibit 105, which was a fake result that was published after the polls had taken place. So it looks like it works hardship on the petitioner when he's told go to court, because he knows that he has to mountain the climb by probably run out of energy. What's going upstairs?
Right, sir. In fact, even in legal practice, you always pray to represent the person who might have won, because that is easier. In practice, it's easier. Because the burden is on the petition, that is the person complaining going to court. The law presumes that the person who won has ordinarily won. And so the politicians in Nigeria in particular rely on this and tell their parties, look, whatever happens, you make sure you win. But that is not good for us. It's not good for justice. It's not good for us. And I think it has come to a stage now that the burden of proof should be upon a preponderance of evidence. If I have established even fair allegation against you, don't say it must be proved beyond reasonable doubt again. Because what is happening really is that our politicians have developed their own jurisprudence now and say, all we want there is that you should win. they then will go and defend, because they know that it is not easy to defend. And for example, where you are thinking of overvoting as a ground and so on, that is extremely impossible to prove now, because you have to call the witnesses from each polling booth to those who counted, how they were thumbprinted and so on. For example, in the presidential election petition, how is that possible? And then that takes me back. I'm sorry for taking you back to my learned brother Uche, on this issue that you don't even use qualification and so on. You need qualification for everything. You even need qualification to marry. Yes, because if you are not mature, you can't marry. If you are not a man, you can't marry. So you need qualification. The issue of qualification is essential to every election. For instance, if you take an illiterate person to the National Assembly, like a situation when a carpenter won as a legal advisor to a party, what is he going to do there? You need this qualification so that where you would know that you cannot, then you know that your client has been robbed, but you can't prove the facts. Please go to the law. Look for his qualifications. The constitution states the qualifications he must possess. And once he does not possess, please, if you do and win, you have done justice not only to your client, but to the society at large.
Yes, Mr. Usman San, thank you so much for your contribution on the conversation. And from our Port Harcourt studio, Chief Festus Oguche, a constitutional lawyer, it's been a pleasure having you. Here in the studio, Oluwale Osaze Uzi, legal practitioner and election expert, as well as former director, Legal Services Department at INEC. As usual, it's a pleasure to have you on the program. And that's how it's been of Good Morning Nigeria today. We hope you enjoyed and learned a lot from our conversation. Join us again for another insightful edition of the program tomorrow. I am Jummai Yusuf.
And I'm Kingsley Osadolo saying, have a nice day.